Hey guys, we're going to talk about adjudication on the merits. Not an expression that we often use in everyday language, but I'm going to show you why this is so important. If you've been sued by a debt collector and you've either won your case directly by a judgment or you have a dismissal with prejudice, and what that means for credit reporting. So I appreciate you watching this video. My name is John Watts. I'm a consumer protection lawyer, and a lot of what I do is represent folks who are sued by debt collectors. And then we also file a lot of lawsuits under the Fair Credit Reporting Act, the FCRA. So we're suing credit bureaus and companies that provide or furnish information to credit bureaus. Now, if you have not subscribed to our channel, feel free to do that. We put out a new video every day and would love for you to have a chance to look at those. So what are we talking about here? Adjudication on the merits. It just means there's been a judgment, a determination on the merits. In other words, whatever the lawsuit was about, if you won your case, that means there's been an adjudication on the merits in your favor. And so let me give you an example, totally outside the context of debt collection. For 26 years now, I've done personal injury cases. So let's say that I sue Bob and say Bob was negligent and he crashed into my car and hurt me. And we go to trial and I lose that trial. Now, would that be an adjudication on the merits? Well, the answer is yes, because a jury and a judge have said Bob's not guilty of being negligent. So here's the question. Can I go sue Bob the next day? Say, well, I'm going to keep suing you till I get a jury that rules in my favor. No. Can't do that. There's this concept called res judicata, just an old expression that for our purposes means if I've already lost the case, I can't go sue again. Okay? Because otherwise there would never be finality. There would never be an end to litigation. People just keep suing. Okay? Or let's say I won. Could Bob then say, well, I really wasn't negligent. I don't owe you any money. I'm not paying you. I want another trial. Well, I mean, he'd have to get a court to say he gets another trial by doing an appeal. He couldn't just go out and file a lawsuit against me saying he's not guilty. When it's been determined by a court that either you win or lose, that's final unless there's an appeal that changes it. Now, what about if I sued Bob for negligence, and I'm going to tie this together with debt collection in a minute. If I sued Bob for negligence and the case was dismissed without prejudice, well, without prejudice means it's not final. It's not a determination. And so without prejudice, could I then go sue him again? Well, yeah, assuming the statute of limitations and all that stuff. Because he can't point to a victory in the first case. Now, what if it's a dismissal with prejudice? That is an adjudication on the merits. At least in Alabama, where I practice, at least in federal court where I practice, when I've looked it up in other states, because I do have people contact me and say, hey, got this debt buyer case or this original creditor case dismissed with prejudice, and they won't take it off my credit report. And so, we'd say, well, let's see what the law says there and make sure it's not something unusual. And then usually we co-counsel with a lawyer in that state. Okay. But a dismissal with prejudice is an adjudication on the merits. And that would mean, going back to my car wreck example, I sue Bob for negligence and there's a dismissal with prejudice. Can I go sue him again? No, because it's been decided he's not guilty. Okay. And so this is something where, again, it's called res judicata. It just means I can't go sue him again. Okay. Well, now let's apply this in the debt collection context. So Midland Funding sues you and you win at trial. Judge says you do not owe $5,000 to Midland Funding. Can Midland Funding sue you again on the same debt and say, well, we didn't like the way that judge did it. We're going to wait a month and then sue you again? No, that's crazy. They can't do that. Well, could they say, well, we're not going to sue you, but we're going to blow up your phone for the same debt? No, you can't do that. We're going to write you letters and say, if you don't pay this, we're going to sue you. No, you can't do that. How about we're going to keep it on your credit report? Here's where they go, well, maybe we can do that. I mean, yeah, we lost at trial, but but you still owe this debt because I, Midland, have decided you owe this debt. No, they can't do that. Okay, when they do that, you need to sue them. Same thing with an original creditor. May be harder to sue without doing a dispute. Okay, but the same concept. All right. Now, if the case is dismissed without prejudice, well, there is no adjudication on the merits. So you can't point to a judge's order saying, hey, I won my case, get this off my credit report. I won my case, stop calling me. I won my case, stop writing me. Because you did not win your case in the sense of an adjudication on the merits. But what if the dismissal is with prejudice? Dismissal with prejudice. That is an adjudication on the merits. And so Midland Funding cannot sue you again. They cannot write to you and say, you better pay this debt because the judge has already said you don't owe the debt. They cannot call you. They cannot credit report on you. Now, they'll fight with us on this. Now, we've sued them dozens of times over this. Okay. And they know that they can't continue to report, but sometimes they still do it anyway. The credit bureaus know that there can't be credit reporting on you. Sometimes they still do it anyway. Okay. And same thing with an original creditor. So Discover Card sues you. This is a case we had years ago. Discover Card sued our client. He actually represented himself. Very unusual. He did this with an original creditor and was successful. He beat them, and then he took our suggestions, our advice, probably 12 years ago, and he disputed it, and they wouldn't take it off. So we sued them. We sued Discover. We sued the credit bureaus. And while they wanted to fuss about it for a little bit, there's really no argument there. Okay? A judge has decided. There's been an adjudication on the merits. And so these credit bureaus can't keep it on your credit report. These original creditors, these debt collectors, whoever has sued you and lost with the dismissal with prejudice cannot do that. At least that's true where I practice, okay, in Alabama and in federal court. That every federal court I've ever been involved with takes this position. So if you have received a dismissal with prejudice, then you may want to look it up in your state. Or if you're in Alabama, contact me. I can definitely give you the Alabama law. But even if you're in another state, feel free to reach out to me. I work with lawyers all over the country. We can look that up, make sure in your state that an adjudication on the merits is what a dismissal with prejudice is, and then see, okay, did this debt collector get rid of this? Did they continue to collect? Did you dispute it with the credit bureaus? Did the credit bureaus keep this false information? Because again, there's been an adjudication on the merits. So they cannot report it on you. They cannot say that you owe this debt. So if we can help you in any way, just reach out to me, alabamaconsumer.com. There's a contact us button on there. You can get a message to us, and then I'll get right back with you. So hope that you enjoyed this. If you want more details, let me know. I don't know how many people will be interested in this video, but if you want more details, I'll show you the actual language from the cases that talk about this so that you can see clearly how this works and how it fits in with that idea of res judicata, which is you cannot bring a lawsuit again for the same thing that you lost. It just makes sense. Well, if you can't bring a lawsuit, you can't threaten me, you can't credit report on me, and you can't continue to collect on me. Okay, again, it just makes sense. Most of these guys know this. Okay, but sometimes the debt collectors get greedy and they think you won't know it. And even if you catch them, you won't sue them. And so they can collect money they're not entitled to. And then they just say, well, you voluntarily paid it. So, you did it out of moral obligation to them. They know what they're doing by breaking the law. And they need to be hammered over and over and over and over again when they do this. Okay, guys, thanks for watching this. And I'll catch you tomorrow. Bye-bye.